Hi guys, welcome to another episode of Attorney Vlogger. Today we continue with our discussion on the law of agency, and specifically we'll be talking about the obligations of the agent. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Now there's an ongoing raffle, and actually today, the day which I upload this video, we'll be holding the raffle draw later. Also, last week we reached 25,000 subscribers. So as promised, I'll be giving away a book on the negotiable instruments law. Please just wait for the raffle video on that. Okay? So now let's begin. So in the last episode, we talked about the power and the authority of the agent to bind the principal to third persons. Now let's talk about the obligations of the agent to the principal. Okay? So in general, the agent has three obligations. Now in general, okay? So the general obligations of the agent are first, the duty of obedience, okay? Under which he has the duty to obey all lawful orders and instructions of the principal within the scope of his agency. The second general obligation is the duty of good faith and loyalty, which simply means that he must act with utmost good faith and loyalty for the furtherance of the principal's interests. And finally, we have the duty to exercise due diligence. In other words, he must exercise reasonable care, skill, and diligence in carrying out the agency. Now, the law gives us specific obligations of the agent, which actually can be considered lumped under those three general obligations. Now, let's take up each of those specific obligations. The first three specific obligations of the agent are all under 1884, Article 1884, and they are consequences of the agent's acceptance of the agency. First, the agent must carry out the agency in accordance with its terms. As such, an agent who is authorized to sell something cannot bind his principal by selling such commodity either directly or indirectly, such as through a sub-agent, to himself. Okay? If he is authorized to sell, that does not mean that the agent can sell to himself. And if the agent sells to himself, then the sale is unenforceable, unless of course the principal ratifies the sale. And this is the ruling in the case of Barton versus Leyte Asphalt. Now, correlate the foregoing rule that the agent must carry out the agency in accordance with its terms with Article 1888, which says that the agent shall not carry out an agency if its execution would manifestly result in loss or damage to the principal. So, given the nature and purpose of the contract of agency, the agent must perform the agency to benefit the principal. Take note that the object of every contract of agency is the execution of a juridical act in relation to a third person, and as such, the obligation of the agent is always an obligation to do. Therefore, in case the agent fails to perform such obligation to do, the only possible remedy is an action for damages. Because remember your oblicon. You cannot compel specific performance in an obligation to do without violating the constitutional prohibition against involuntary servitude. So under Article 1884, in case the agent fails to perform the agency, the agent has the obligation to answer for damages which the principal may suffer. And this is the second specific obligation of the agent, okay? Under 1884. In case the agent fails to perform the agency, the agent has the obligation to answer for damages which the principal may suffer. Since, of course, this constitutes a betrayal of the trust and confidence reposed upon the agent by the principal. The next obligation of the agent, which is still under Article 1884, is to finish the business already begun upon the death of the principal, in case delay should entail any danger. So, even if the death of the principal extinguishes the agency, the agent should continue and conclude any business which had begun before or at the point of death of the principal, but only if delay will cause danger. We'll talk more about the effects of the death of the principal in the appropriate episode. Okay? Now, 1884 earlier discussed, dealt with the situation where the agent accepted the agency. For the next specific obligation of the agent, Article 1885 provides for the situation where the agent does not accept the agency. So in case the agent declines the agency, the agent has the obligation to observe the diligence of a good father of a family in the custody and preservation of the goods forwarded to him by the owner in case he declines an agency until an agent is appointed. So here, the owner has a correlative obligation, either to take charge of the goods or to appoint an agent as soon as practicable. Next, now, as a general rule, the principal should be the one to advance the sums necessary for the execution of an agency. However, the contract of agency may have a stipulation that the agent shall advance the necessary funds. So the next specific obligation of the agent is under Article 1886. If there is such a stipulation that the agent shall advance the necessary funds, then the agent must advance the necessary funds. The exception where the agent doesn't have to advance the funds is when the principal is insolvent. Okay? Because in this case where the principal is insolvent, the principal will not be able to reimburse the agent. Also, it is a ground to extinguish the agency, but again, we'll talk about extinguishment of agency in the appropriate episode. Now, as to power and authority, remember the discussion in the previous episode that the general rule is that the agent has the obligation to act within the scope of his authority under Article 1881. And this is qualified by the doctrine of implied powers in agency, that the agent may do such acts as may be conducive to the accomplishment of the purpose of the agency, which is found in the same article. It's also qualified by the rule in Article 1882 that the limits of the agent's authority shall not be considered exceeded should it have been performed in a manner which is more advantageous to the principal than that specified to him. Now, as for the duties of the agent to the principal, following the obligations of the agent with regard to power and authority, we have the following duties of the agent. First, duty of obedience. Under Article 1887, this article obligates the agent to act in accordance with the instructions of the principal. And if there are no instructions, then the agent must do all that a good father of a family would do as required by the nature of the business. And we already discussed this in the previous episode. Just remember the following. First, the rule on instructions applies between the principal and agent and not necessarily to third persons, because those third persons may simply rely on the written power of attorney, the SPA or the GPA as the case may be. Also, departure from the instructions of the principal is permitted in the following cases. First, if the agent performs the agency in a manner more advantageous to the principal under 1882, and second, in case of sudden emergency not caused by the agent's fault and there is no time to communicate with the principal, but something must be done and a strict compliance with the instructions becomes impossible or detrimental to the interests of the principal. Okay, this is agency by necessity, which we also discussed in the previous episode. So just consider this as a review. Now we go to the duty of the agent of good faith and loyalty. Under Article 1889, if there is a conflict between the agent's interests and the interests of the principal, and the agent prioritizes his own interests above those of the principal, then the agent will be liable for damages. 1890 provides for the obligations of the agent in case he was authorized to borrow or lend money. So the rules are as follows. If the agent has been empowered to borrow money, the agent himself may then be the lender at the current rate of interest. But if the agent charges interest higher than the current rate, then he has the obligation to return the difference to the principal. Okay? Next rule. If the agent has been authorized to lend money at interest, he cannot borrow it without the consent of the principal. If he does, then the agent becomes liable to the principal for damages which the principal may have suffered. The consent of the principal is necessary, because there may be a conflict of interest. The agent may be a bad debtor and he will not pay, which will be prejudicial to the principal. Remember also that this is one of the cases where an SPA is necessary. The next one is from the law on sales, if you still remember. Under Article 1491, Paragraph 2, the agent is prohibited from acquiring, by purchase, even at a public or judicial auction, either in person or through the mediation of another, the property of the principal whose administration or sale may have been entrusted to him, unless, of course, the principal consents to such sale. Take note that the violation of this rule will result in the sale being void. But take note also that this prohibition only applies during the existence of the agency. As such, a sale made after the agency is valid. Also, in case a sale was made during the agency, the remedy is simply to make a new contract after the agency ends. Can you ratify this? Of course not. Remember, void contracts cannot be ratified. Just make a new contract after the agency ends. Next specific obligation. The agent has a duty to exercise due diligence. So, I already mentioned this earlier, but the duty to exercise due diligence involves following the instructions of the principal. In the absence of instructions, the agent, in the execution of the agency, must do all that a good father of a family would do, as required by the nature of the business. As a consequence of this duty, the agent also has the obligation not to carry out an agency if its execution would manifestly result in loss or damage to the principal. Moreover, under Article 1909, the agent has the obligation to answer for his fraud or negligence, which may have occurred in the conduct of the agency. Take note, however, that in the case of negligence, it will be judged with more or less rigor by the courts. Okay, so the court will see how negligent were you, etc. It will take into account several factors depending on whether the agency was for compensation or not. As such, in order to determine the existence of fraud or negligence, the agent has the obligation to make a full disclosure or complete account to his principal of all his transactions and other material facts relative to or relevant to the agency. Which brings us to the next obligation of the agent, which is under 1891, every agent is bound to render an account of his transactions and to deliver to the principal whatever he may have received by virtue of the agency, even though it may not be owing to the principal. That's very important, okay? Take note that this obligation is absolute. So much so that any stipulation exempting the agent from the obligation to render an account shall be void. Take note also of the doctrine in Domingo versus Domingo that an agent who takes a secret profit in the nature of a bonus, gratuity, or personal benefit from the buyer without revealing the same to his principal, that agent is guilty of breach of loyalty, and therefore the consequence is that the agent will now forfeit his right to collect the commission, even if the principal does not suffer any injury, or that even if the principal has obtained better results, or even if the agency is gratuitous, or even if such is allowed under usage or other customs. Okay? Because this rule that the agent is bound to render an account is up there in order to prevent the possibility of any wrong, not to remedy or repair any damage. Okay? So this rule is for the prevention of wrong and not as a remedy to repair any actual damage. And in the same case, by taking such profit, bonus, or gift, the agent thereby assumes a position wholly inconsistent with that of being an agent for his principal. And the principal now has a right to treat that agent insofar as the commission is concerned as if no agency had ever existed. Okay? The fact that the principal may have been benefited by the valuable services of the agent does not exculpate the agent, who has only himself to blame for such result by reason of his treachery or perfidy, meaning disloyalty. Remember that agency involves a relation of utmost trust and confidence, which is reposed by the principal in the agent, and that is the root of the duty of loyalty and the consequent duty to render an account from the agent to the principal. Take note, however, that the obligation to render an account does not apply in the following cases. First, if the agent only acted as a middleman with the task of merely bringing together the parties, okay, merely bringing the buyer and the seller, and then those two will now negotiate the terms and conditions of the transaction by themselves. In such a case, there is no obligation to render an account. Second, if the agent had informed the principal of the gift, bonus, or profit which he received from the buyer, and the principal did not object. So, third, if a right of lien, okay, a lien exists in favor of the agent. An example of this lien is in Article 1914, in which case the agent may retain in pledge the things which are the object of the agency until the principal reimburses either the sums necessary for the execution of the agency under 1912 or indemnity for damages which the execution of the agency may have caused to the agent without his fault or negligence under 1913. And I'll talk about this more in the obligations of the principal. Now, connected to the obligation to render an account is the liability of the agent for interest. Under 1896, the agent owes interest on the sums he has applied to his own use from the day on which he did so, and on those which he still owes after the extinguishment of the agency. Now, with that, we can move on to a discussion on the delegation of authority by the agent. Article 1892 provides the rule that the agent may appoint a substitute, but only if the principal has not prohibited the agent from appointing a substitute. Take note of that, okay? Only if the principal has not prohibited the agent from appointing a substitute. The substitute or sub-agent is a person to whom the agent delegates as his own agent the performance of an act for the principal which the agent has been empowered to perform through his representative. In short, the substitute is the agent of the principal's agent. Okay? Now, substitution produces certain effects as between the principal and the agent, and as between the principal and the substitute, and as between the principal and third persons. Now, first, as between the principal and the agent, we have the following rules. If the agent is empowered to appoint a substitute, and the person appointed by the agent is one who is chosen by the principal himself, then the agent is not liable for the acts of the substitute. Second, if the agent is empowered to appoint a substitute and the agent is allowed to choose whom to appoint, then generally the agent is not liable for the acts of the substitute unless the person appointed was notoriously incompetent or insolvent. Third, if the agent is not empowered to appoint a substitute, but he is not prohibited from making an appointment, then the agent shall be responsible for the act of the substitute. And fourth, if the agent was prohibited from appointing a substitute and he still appoints a substitute, then the agent acts beyond the scope of his authority, and therefore he is liable to the principal for the acts of the substitute. Now, on to the next set of rules, as between the principal and the substitute. Now, if you remember your oblicon, you will recall the principle of relativity of contracts under Article 1311, that contracts take effect only between the parties, their assigns and heirs, subject to certain exceptions. So, applying the principle of relativity in case of appointment of a sub-agent, it should be that the sub-principal is a stranger to the contract between the agent and the sub-agent. However, 1893 provides another exception to the principle of relativity of contracts when it allows the principal to bring an action against the substitute with respect to obligations which the substitute has contracted under the substitution in two cases. First, when the agent has not been given the power to appoint a substitute, but he was not prohibited from appointing one. And second, although empowered to appoint a substitute, the agent appoints one who is notoriously incompetent or insolvent. Of course, the principal may also bring an action against the agent himself with respect to the obligations which the substitute has contracted, together with the substitute himself. And on to the next set of rules, as this time as between the principal and third persons. If the substitution is not prohibited, then it is valid, and the acts of the substitute, they will bind the principal. But if the substitution is prohibited, all the acts of the substitute shall be void, unless, of course, the principal ratifies the acts of the substitute. Of course, following the discussion in the last episode, when the law says void here, we should understand it to be unenforceable rather, no? Because void contracts, as stated, are not susceptible of ratification. Okay? In any case, again, if the substitution is prohibited, all the acts of the substitute shall be void, or better, unenforceable, unless, of course, the principal ratifies the acts of the substitute. Okay? Now, take note, if the authority of the substitute comes from the principal, the death of the agent who appointed him does not affect his authority. But where he acts under the authority of the agent, the death of the agent terminates his authority, even though the power of substitution is given in the original power. Okay? Now, what if instead of allowing the appointment of a substitute or even appointing one himself, the principal instead appoints two or more agents? In such a case, the responsibility of two or more agents, even though they may have been appointed simultaneously, is not solidarity. Okay? If solidarity has not been expressly stipulated. Remember your oblicon, okay? Because this follows the general principle in oblicon that an obligation is presumed to be joint, and that there is solidarity only when the obligation expressly so states or when the law or the nature of the obligation requires solidarity. So in this case, where the principal appoints two or more agents, each agent is liable only for his proportionate share as the case may be. Okay, they will only be solidarily liable only if it is so expressly stated, or if the law so requires, or the nature of the obligation so requires. Okay? Now, if solidarity has been expressly agreed upon, Article 1895 provides that each of the agents is responsible for the non-fulfillment of the agency and for the fault or negligence of his fellow agents, except in the latter case when the fellow agents acted beyond the scope of their authority. Of course, this is without prejudice to the right of the innocent agent to recover from the guilty agent later on. So there can be recovery. For our last topic, let's talk about the specific obligations of a factor or commission agent. And the commission agent is one whose business is to receive and sell goods for a commission, and who is entrusted by the principal with the possession of goods to be sold. The commission agent may act either in his own name or in the name of his principal. So aside from being liable for the obligations mentioned earlier, okay, the commission agent is also subject to the specific obligations which I discussed. The commission agent has additional obligations. Special siya. Okay? Now, first, under Article 1903, the commission agent shall be responsible for the goods received that he received in the terms and conditions and as described in the consignment. Meaning, the quantity, the quality, the physical condition of the goods. In order for him to avoid liability, the commission agent should make a written statement of the damage or deterioration if the goods received are not in accord with the description in the consignment. Under Article 1904, if the commission agent handles goods of the same kind and mark which belong to different owners, then he has to distinguish the goods by countermarks, and he should designate the merchandise respectively belonging to each principal. Next, Article 1905 governs sales on credit by the commission agent. The rule is that the commission agent cannot, without the express or implied consent of the principal, sell on credit. In other words, the commission agent cannot sell on credit unless he has the express or implied consent of the principal. So if the commission agent sells on credit without authority, then the principal is given certain options under the law, okay? The principal may demand from the commission agent payment in cash, but the commission agent shall be entitled to any interest or benefit which may result from such sale. Because if the principal can get that, then it will result in unjust enrichment. Okay? Or another option given to the principal would be that the principal may ratify the sale on credit and bear the related risks and advantages thereof. Now, if the commission agent sells on credit with the authority of the principal, then he has the duty to inform the principal through a statement of the names of the buyers. If he fails to do so, then the sale shall be deemed to have been made for cash insofar as the principal is concerned. Meaning that, of course, he has to pay for it, no? Regardless of whether he actually gets paid or not. That's under 1906. Now, in case the commission agent does not collect the credits of the principal at the time when they become due and demandable, then the agent shall be liable for damages, unless, of course, he proves that he exercised due diligence for that purpose. And that's under 1908. Finally, we have Article 1907, which provides for the rule on guarantee commissions, otherwise known as del credere commissions. And these are commissions where, in consideration of an increased commission, mas mataas yung pera, the factor or commission agent guarantees to the principal the payment of debts arising through the agency. The purpose of a guarantee commission is to compensate the agent for the risks he will have to bear in the collection of the credit due to the principal. An agent who receives a guarantee commission is known as a del credere agent. So under 1907, if the commission agent receives a guarantee commission, a del credere commission, then he has the obligation to bear the risk of collection. And he has to pay the principal the proceeds of the sale on the same terms that have been agreed upon with the buyer. Okay? However, take note that the liability of the commission agent does not preclude the principal from resorting to the purchaser in order to obtain payment at any time before the debt is paid. Okay? So he can go straight to the principal can go straight to the buyer if he wants at any time before the debt is paid. Okay? So that's it for our discussion on the obligations of the agent. I hope you may have picked up a thing or two, and I hope to see you next time, guys. See you soon. Bye.